Hey guys, I'm sure most of you might have heard of the Enrica Lexie incident which took place in February 2012, in which two of our Indian fishermen were shot and killed by two Italian guards on an Italian ship known as Enrica Lexie. The very next day, an FIR was filed against these two guards under Section 302 of our Indian Penal Code. After that, the case grew so massive that it actually resulted in an international dispute between two friendly countries, India and Italy. And finally, as of today, the case has finally culminated in the International Permanent Court of Arbitration in May 2020. Now, I don't like to comment who won and who lost, but I like to see it as a case study of the international maritime law, particularly on the provisions of UNCLOS 1982, which gives us a reason to check the compatibility of our domestic law with the international conventions which we ratified. Now, in this video which I have made, I have put together the chronological events in which the case took place, which may be of interest to many of you in the marine field. I have actually divided it into two parts. Part A consists of the events which took place in India, from our Kerala police station to the Supreme Court, and Part B consists of the events which took place in the International Permanent Court of Arbitration. Please do watch and discuss. Thank you.
Enrica Lexie, a case study Part A. The Republic of Italy enacted a law of Parliament No. 130 of 2 August 2011, which provided for deployment of Italian military navy contingents on Italian flagships, to counter the growing menace of piracy on the seas. While the Italian flag merchant vessel Enrica Lexie was having such a military protection detachment on board, and while heading for Djibouti on 15 February 2012, it came across an Indian fishing vessel, St. Antony, which it allegedly mistook to be a pirate vessel, at a distance of about 20.5 nautical miles from the Indian sea coast off the state of Kerala. The security guards, two Italian Marines, fired at the suspect fishing boat, allegedly, without any warning. In the unfortunate incident, two Indian fishermen, 25 years old Ajesh Pink and 46 years old Valentine Gelastine, lost their lives. The incident became sensational, emotional, political, and legal. The incident finally evolved into an international dispute between two nations, India and Italy. It was against this background, the round one of the case unfolds. An FIR was lodged with the Coastal Police, Kerala, under Section 302 read with Section 34 of the Indian Penal Code, IPC, in respect of the firing incident leading to the death of the two Indian fishermen. On 19 February 2012, Massimiliano Latori and Salvatore Girone, two Italian mariners, were arrested by the Coastal Police Kerala and were in judicial custody thereafter. The case appears before the Honourable High Court of Kerala, showing indications of a long legal battle in the days to come. The mariners files writ petition No. 4542 of 2012 before the Kerala High Court, under Article 226 of the Constitution, challenging the jurisdiction of the state of Kerala and its coastal police to register the FIR and to conduct investigation. The Honourable High Court, however, upheld the actions of the state government. Aggrieved by the aforesaid judgment of the Kerala High Court, the petitioners filed Special Leave Petition, Civil, No. 20370 of 2012, before the Honourable Supreme Court of India challenging the order of dismissal of their writ petition by the Kerala High Court. The scene now shifts to the apex court of the country, Honourable Supreme Court of India. Round 2 starts before the Honourable Supreme Court of India before the bench headed by the Chief Justice of India Justice Altamis Kabir along with Justice Chelamishwar. The Italian government was represented by the renowned lawyer Harish Salvi. The main arguments put across by Salvi against the action by the Kerala State Police can be summarized as below. the determination of international disputes and responsibilities as well as proceedings connected therewith, must necessarily be between the sovereign governments of the two countries and not constituent elements of a federal structure, that is, state governments. The incident occurred 20.5 nautical miles from the coast of India, that is, beyond territorial waters. Therefore the unlawful arrest and detention of the Italian mariners by the state of Kerala was in violation of the long-standing customary international law, principles of international comity and sovereign equality amongst states. The provisions of Maritime Zones Act cannot be applied in the facts of the case, since the Maritime Zones Act, 1976, which is a domestic act, is a departure from UNCLOS, and Article 27 of UNCLOS was not a part of the Indian domestic law. Under Article 97 of UNCLOS, incident of navigation is not a criminal offence, but a matter of competency of the seafarer to be addressed by the respective flag state. On 13 January 2013, the Apex Court of the country pronounced its detailed judgment in Special Leave Petition No. 20370 of 2012, Republic of Italy and others versus Union of India and others. The Honorable Bench of Chief Justice Altamis Kabir and Justice Chelamishwar unambiguously answered most of the queries raised in the SLP. Let's have a brief look into the salient findings of the judgment in the coming slide. The first issue resolved in the judgments was the validity of the Maritime Zones AC of 1976, which was alleged to have provisions contradictory to the United Nations Convention on the Law of the Sea, 1982. The Apex Court held that the Maritime Zones Act 1976 has nothing contradictory to UNCLOS 82 and a law passed by the Parliament of India cannot become unconstitutional simply because it has extraterritorial jurisdiction. Hence the Maritime Zones Act of 1976 is constitutionally valid. The also court reiterated that Government of India is fully justified to proceed against the Marines alleged to have involved in a heinous crime of killing two its bona fide citizens. And more importantly, Supreme Court reaffirmed that the courts of the country have full jurisdiction to adjudicate their trial. The Honorable Court, however, agreed with the Italian view that the determination of international disputes and responsibilities as well as proceedings connected therewith, must necessarily be between the sovereign governments of the two countries and not by constituent elements of a federal structure. Hence the court held that the State Police of Kerala cannot investigate the matter, which therefore needs to be reinvestigated by a central government agency and a special court is to be constituted to undertake the trial. It was against this background that the round 3 of the case started with a fresh investigation by the National Investigation Agency, NIA. Incidentally, the Honorable Court through this landmark judgment, also addressed several other related queries, with lot of academic interests to any maritime law student. Up to where do we have territorial jurisdiction of India? Can India frame national laws with extraterritorial jurisdiction? How far can we exercise our sovereign rights in maritime zones? Do we need national laws to implement a ratified international convention? What is the status of an international public maritime law in the absence of municipal laws? Can we frame national laws conflicting with an international convention which we have ratified? Can executive enforce provisions of a ratified international convention till such time the national laws are framed? And so on. Leaving scope for maritime law schools to keep debating. Round 3 of the case started on 4 April 2013, when the National Investigating Agency (NIA) re-registered the case as RCO 4/2013 and took up the investigation. The Ministry of Home Affairs vide Notification No. 17,011/27/2012, notified the Chief Metropolitan Magistrate, Patiala House Court, New Delhi, as special designated court, for the case. On 27 November 2013, The NIA, having completed its investigation, submitted its investigation report to the Ministry of Home Affairs, New Delhi, for sanction of prosecution under the Suppression of Unlawful Act, SUA 2002. On 17 January 2014, the Ministry of Home Affairs accorded sanction to prosecute under Section 3(1) of, which deals with act of violence against a person on a ship which can warrant punishment up to 10 years, and under Section 3(1) (gi), which warrants death penalty, if such violence leads to death of the person. On 6 February 2014, the Ministry of Home Affairs reversed its position and modified its prosecution sanction by limiting it only to Section 3(1) of, dropping Section 3(1) (gi), which warranted death penalty. Barely 2 weeks later, on 24 February 2014, to the surprise of many, the Ministry of Home Affairs filed an affidavit before the Supreme Court expressing its opinion that the SUA Act is not attracted in this case. And on 3 March MHA withdrew its sanction to prosecute under the SUA Act, leaving the NIA only option to charge sheet the case under the sections of the Indian Penal Code relating to murder, attempt to murder and causing damage to the fishing boat. Now that the SUA Act has been dropped, the Marines challenge the investigation by NIA as irrelevant, and seek permission to leave the country. On 12 September 2014, Supreme Court permitted the Marines to proceed to Italy for rehabilitation and medical treatment. 26 June 2015, Italy approached the International Tribunal for the Law of the Sea for arbitration under the United Nations Convention on Law of the Sea, Appendix 7. On 24 August, as a provisional measure, International Tribunal for the Law of the Sea ordered both the parties to suspend all court proceedings and refrain from starting new proceedings that may aggravate the dispute. On 26 August 2015, the Supreme Court of India suspended its proceedings on the matter till further orders. From a small criminal case before a local police station from a small Indian state of Kerala, the case grew into an international dispute between two countries, Italy and India. It leads to the round 4 starts before the International Tribunal for the Law of the Sea for arbitration under the UNCLOS at Hamburg, Germany. And the rest is history. We will talk in detail about the events happened before the International Tribunal for the Law of the Sea and later before the Permanent Court of Arbitration in the next part. Thank you for the patient hearing.